The Court of Appeal in the Supreme Court and Moot Court of Victoria is in session, calling the matter of Commercial Sparks Engineering, Rebuttal Joseph. May be seated.
Good morning. Today we're here on appeal from a decision of Justice Carlos in the Supreme Court in the first instance against judgments of Apellant.
If it please the Court, my name is Stephanie Prolisco. I appear with my learned colleagues Miss Naomi Kesson and Miss Megan Clover for the applicant in this matter, Commercial Sparks.
May it please the Court, my name is Mr. Syed and I appear on behalf of the Respondent alongside my learned colleague Mr. Kara.
Your Honour, this case concerns the distinction between employees and independent contractors and the relevant effect of this distinction on employees and those who contract for services with regards to workplace accidents. Whether this Court will limit their consideration in deciding this distinction to only the indicia of what is a worker or a contractor, or whether they will more fully consider the agreements and the intention of the parties in contracts for work. This is an appeal against the decision of Justice Carlos in the Supreme Moot Court of Victoria. It is our submission that the trial judge was wrong in his finding that the respondent met the definition of a worker required to claim compensation under the Accident Compensation Act 1985 Victoria. Your Honour, may I please dispense with the full citation from this point forward?
That's fine.
As such, he erred in awarding damages without proving negligence on the appellant's behalf, and the respondent was responsible for his own injuries, either in whole or in part by his own negligence. The appellant seeks to have this decision struck down. Your Honour, would you like a summary of the facts read out?
No thanks. Can you you're going to deal with the issue of whether the worker?
Yes. The definition of worker under Section 5 and 8 of the Accident Compensation Act is the main principle. If the Court agrees that the respondent does not meet this definition, the Court will then be asked to look at the relevant provisions of the Wrongs Act 1958 Victoria.
Let me stop you there. Isn't it very clear that the applicant is a worker, deemed worker under the Act?
We submit to the Court that it is not clear that there is significant basis that the respondent is actually not a worker of Commercial Sparks Engineering based on the wording of the Act.
If you can go into detail about that to assist the Court, please.
I will deal with this in my first submission. Do you want me to begin with my submissions now? The appellant submits that Mr. Joseph is not a worker of Commercial Sparks Engineering as per the definition in Section 5 of the Accident Compensation Act, which states a worker is an individual who performs work at the employee's direction, instruction or requirement, whether under a contract of employment or otherwise. The respondent was present on the worksite at the instruction of Oversight Electrics Proprietary Limited, a company which the respondent and his brother established after he terminated his employment with the appellant. In Marshall versus Whittaker Building Supply Company, 1963, 109 CLR, may I dispense with those further citations? In which the High Court held that the ultimate question is whether a worker carries on trade on his own behalf. We submit that Mr. Joseph was employed by Oversight Electrics Proprietary Limited. Oversight Electrics has contracted with the appellant for the provision of electrical supervisory work. The respondent was given a single direction by the appellant's project manager: fix the fault. Following the Victorian WorkCover Authority and another v. Game, the power of control for the work to be performed remained with Mr. Joseph. It was Mr. Joseph who decided how to perform the work, and as an experienced and competent electrical technician, he remained in control of the work being performed. Our learned friends will also argue that Section 8 is applicable. However, Section 8 of the Accident Compensation Act provides an outline of when contractors are considered workers of the principal, but does not extend to the situation present in this case. Section 8.1c requires that 80% of services provided pursuant to the contractual arrangement provided by the same individual, being either the contractor, if the contractor is a partnership, or if the contractor is a body corporate, a member of the director, shareholder, employee of the body corporate, or if the contractor is a trustee of a trust, a person who may benefit under the trust.
Can I stop you here, Councillor?
Yes.
Can you take us to the facts of this case?
Yes.
And if you have a look at the case law, and in particular, there's a case of Sharif, the court says you have to look at the totality of the person's employment situation
Yes.
to determine whether they're a worker.
Yes.
Now, if you take us to the facts to show why you believe that this person is not a worker, because if you have a look, he provided a fortnightly invoice to commercial sparks,
Yes.
paid $65 an hour. He was told how to do his job. He was provided everything but the tools.
And he only worked for commercial.
Didn't work for another party. And of significance, the gloves that caused the problem were supplied by commercial sparks.
Your Honour, may I confer with my co-counsel for one moment?
That's fine.
Your Honours, after conferring with my co-counsel, we submit to the court that because the respondent was employed by Oversight Electrics, which is a proprietary limited company, the Act specifically excludes proprietary limited companies under Section 8.1c, and therefore he is not deemed to be a worker under he can't rely on 8.1c as to be a worker because it doesn't deal with proprietary limited companies.
Let's put aside Section 8.1c. What do you say then?
If we put aside Section 8.1c, if you look at the other cases that deal with the indicia, in Bodrib Sawmilling Company, the court considered whether the employer exercises or has the right to exercise control over the manner in which the work was performed. In this case, Mr. Joseph wasn't told how to perform the work in which he was then injured. He was only given the direction of fixing the fault by the appellant, and he then took it upon himself to fix the fault in the manner in which he saw fit as an electrical contractor.
What about the cases of the courier drivers that work for TNT in these companies and they're told by the TNT to register a company, ride their own van, pay their own insurance, and the courts have found that they're deemed workers because all they work for is So one company, TNT, for example.
Your Honour, I believe that the Accident Compensation Act has a specific section under Section 8 that deals with drivers, and it's dealt with exclusively in the Act, whereas in this case the electricians aren't specifically dealt with under the Act, therefore they will fall in the category of Section 8.1 and they would need to meet those criteria.
Are you familiar with Sharif's case? Justice Beach's decision in the Court of Appeal?
No, Your Honour, I'm not.
In the matter of counsel, in the matter of Sharif and Elazak, we've got a situation where the employee, or he was saying he was an employee, actually had his own company. At first instance in the Supreme Court, Justice Robson found he was an employee under the Accident Compensation Act. However, at the Court of Appeal, was overturned on the basis that he had a high degree of control. He employed his own employees and did the work as he saw fit. The employer had subcontracted him to perform various works at a building site, but the Court of Appeal found that because he was able to choose the way of the work, that was the way the work was done, and with his own employees, they found he was not an employee of the defendant in that instance. Does this apply with commercial?
And what was telling also in that case is the fact that the court found it most significant the fact that it was the plaintiff had his own employees, whereas in this case, Mr. Joseph.
Commercial has supplied the employees to the respondent.
May I confer with my co-counsel? Your Honours, if it pleases the court, we'll address this matter in rebuttal.
Excellent. Next speaker. Thank you.
Your Honours, my name is Naomi Keeson. I am junior counsel for the appellants in this matter, and I'll be dealing with two submissions this morning. My submissions are in line of those of my learned colleague, Ms. Porolsky. My first submission is that Mr. Joseph must establish that Commercial Sparks Engineering breached their duty of care through the Wrongs Act 1958 Victoria. Your Honours, if you don't mind, may I please dispense with full case citation? Thank you. We submit that there was a duty of care on behalf of Commercial Sparks Engineering, but this duty of care was not breached. My second submission is on the basis that our learned friends have submitted that it was solely our client, Commercial Sparks Engineering, that caused the harm suffered by Mr. Joseph. We submit that this is not the case under Section 51(1)(a) of the Wrongs Act. If it pleases Your Honours, I would like to start with my first submission this morning.
Thank you.
As my senior counsel, Ms. Porolsky, stated, Mr. Joseph is not a worker under the Accident Compensation Act. As a result, for Mr. Joseph to be able to claim damages this morning, it must be done via the Wrongs Act. Your Honour, we submit that there was a duty of care between our client, Commercial Sparks Engineering, but this duty of care was not breached. Under Section 48(1)(a) of the Wrongs Act, it must be considered that a risk was foreseeable. As per Wyonshire Council and Shirt, foreseeability of risk and the likelihood of risk are different things. We submit that the risk in this case was foreseeable and therefore it was protected against. Under Section 48(1)(b) of the Wrongs Act.
Counsel, may I interrupt you there?
Yes.
You talk about foreseeability. Exactly how?
I believe that it would have been foreseeable for we submit that it would have been foreseeable for an electrician to be electrocuted if they failed to turn off power, which happened in this case. He failed to disconnect the supply of electricity, and which effectively meant he could be electrocuted. That would have been a foreseeable risk for any reasonable electrician in the trade.
Thank you.
Can I interrupt?
Yes.
Your opening position is that there is a duty of care.
But the duty of
He's
care
not an
was-
employee.
he would have to establish that there was a duty of care under the Wrongs Act instead of under the Accident Compensation Act. May I continue, Your Honours? Under Section 48, subsection 1B of the Wrongs Act, the risk that faced the respondent must not be insignificant. That is, that the risk must not be far-fetched or fanciful, again, as per Wyong Shire Council and Shirt. We believe that the risk of being electrocuted if the power wasn't disconnected would have been a significant risk and therefore not insignificant. However, as per Section 48(1)(c) of the Wrongs Act again, there must be precautions taken. We submit that our clients did take these precautions. These were taken through the job safety assessment and the risk assessment, and the fact that Mr. Joseph was supplied with personal protection equipment. All of these were actually available to Mr. Joseph.
Council, who performed the job safety assessment?
I believe the job safety assessment was done through Commercial Sparks. Do you mind if I quickly confer with my colleagues? Thank you.
The respondent. He did it himself. What says it on the fax?
I'm sorry, Your Honours, I was incorrect. Mr. Joseph himself performed the risk assessment.
So therefore, where does the liability arise with commercial?
It does not. He performed it incorrectly himself, and therefore it was his own error.
What was the cause of what caused the accident?
The accident was caused by his failure to turn off the electricity in the area, and when he pulled the wire, it still would have been filled with electricity.
What about the provision of gloves?
He was provided with gloves, I believe, but as far as I'm aware, he was wearing the wrong gloves. He was wearing electrical gloves instead of leather gloves instead of the personal protection gloves.
So you're saying Commercial Sparks provided the gloves to Mr. Joseph?
Yes, they provided the personal protection gloves to Mr. Joseph and the leather gloves, but he was wearing the incorrect ones. He was wearing leather gloves at the time of the incident. He should have been wearing the personal protection gloves.
They were provided by Commercial Sparks?
Yes, as far as I'm aware, Your Honour. Are you happy for me to continue? Thank you. As per the case of Romeo and Conservation Commission, Northern Territory, it is the response to the relevant risk by a reasonable person which dictates whether risk must be guarded against to conform by legal obligations. We submit that the respondent didn't act like a reasonable person in this scenario. A reasonable person would have been wearing the correct equipment and would have turned off the electricity prior to playing with live wires. And in doing so, Mr. Joseph failed to take reasonable care and sustained injury by failing to take personal responsibility for his own safety.
Council, you talk about a reasonable person wearing the correct equipment. Who provided the respondent with the leather gloves?
As far as I'm aware, Commercial Sparks did, our client.
So that doesn't assist your case, does it?
We also provided him with the correct gloves to wear as well.
Where's that in the facts?
In the facts it says Mr. Joseph was wearing leather Commercial Sparks engineering gloves. On page 4.
Sorry, Your Honour, I'm just conferring with one of my learned colleagues. There shouldn't be a moment.
Because you can wear those gloves as long as the power's turned off. You can wear those gloves as long as this is the electrical safety in dealing with it. You can wear leather gloves as long as it's turned off. They were sending him to a job where the power was going to be turned off.
Okay, yeah, thank you. Your Honours, there is on page 5 that the respondent was provided with equipment box which included personal protection equipment. I do also have in front of me the code of practice for safe electrical work. If you give me a moment, I'll just see if I have any further information about when it was published. 1997, low voltage electrical installations. On page 10, and we are happy to give this to
Just
you.
on page 5, you say, but is there a reference to other gloves? Is there only one set of gloves, or is there more than one set of gloves?
There's no reference to the gloves specifically, but it does say personal protection equipment. So you are correct, there is no reference to any other gloves. That was an assumption made on my behalf.
And further on states that the respondent wears commercial Sparks engineering clothing.
Yes.
Proceed, please.
As per the code of practice for safe electrical work, on page 10, it does say that leather gloves may be considered when performing de-energised electric work. But again, the client, Mr. Joseph failed to turn off the electricity, and therefore the equipment he was provided would have become insufficient on that basis.
So if you're saying there's only one set of gloves and they were leather, what do you say about liability to your client?
The gloves would have been sufficient if Mr. Joseph had taken the right action and actually turned off the power. He failed to turn off the power and therefore the gloves became insufficient. But as an electrician and, as per Rogers and Whittaker, he possesses special skills and is, as such, required to exercise the degree of skill and care expected of such a person. You would expect that an electrician would turn off the power and would know that that was required.
But the applicant is an electrical company as well,
Yes.
not just another employer or another company. They are electrical contractors. So isn't it reasonable to expect that whatever equipment they give you, in particular gloves, would be adequate? If they're electrical contractors and you are an electrician yourself, you'd expect that they wouldn't give you gloves that aren't adequate, wouldn't you?
You would expect they would, and as per the Code of Practice for Safety Electrical Work, it does say that leather gloves are considered sufficient when performing de-energised electrical work. So if he had taken the right precautions and had turned the power off, the gloves would have been sufficient. His failure to turn the power off was essentially the cause of the incident.
Thank you.
Thank you.
Thank you, Your Honours. In light of the fact that I have 1 minute remaining in my time, I would like to conclude and refer yourselves to our written submission, simply because I'm running out of time. We conclude that essentially it was Mr. Joseph's own fault in failing to turn off the power and exercise reasonable skill and care that caused his own injury. There was a duty of care, but it was not breached by our client, it was breached by Mr. Joseph's. Thank you, Your Honours.
Thank you.
Your Honours, my name is Megan Clover. I'm representing the Junior Counsel. Can I please dispense with full citations? I'm going to submit that the respondent's injuries were a result of his own negligence. The respondent's injuries were a result of his own negligence and not the appellant's negligence under the Electrical Safeties Act 1988 and the Electrical Safety Installations 2009. Under the Act and regulations, a certified electrical compliance was required to be issued for all electrical installation work carried out by the respondent. The issue of a certificate of compliance is imperative to understanding the duty of care, not only to the work completed, but in understanding that the respondent was responsible for conducting his own risk assessment independent of the appellant's risk assessment and risk analysis. Under the Electricity Safety Act 1988, a certificate of compliance means a compliance completed under Section 44 for electrical installation work carried out by a licensed electrical installation worker. The respondent was required to work to the certificate of compliance regardless of the terms of the employment of the appellant. Justice Carlos erred when he stated that the risk assessments were controlled in such a way that the respondent did not have the ability to perform the risk assessment at his own discretion. We submit that the respondent was required to carry out his own certificate of compliance independent of the appellant's risk safety assessment. The respondent, underneath the Electrical Safety Act 1988, was required to work using the ASNZZ 3000 as well as the State Electricity Commission's Wiring Regulation 1992, Regulations 1. Both required the respondent to ensure the disconnection to the supply of electricity for adequate precautions to be taken to prevent electrical shock. The respondent clearly did not take adequate precautions to prevent electrical shock as he received an electric shock while pulling cables. Also, under the State Electricity Commission's Wiring Regulations 1992, as I guide it reasonable to require the defendant to have in contemplation the risk of injury that has eventuated. On this basis, we submit that the failure to disconnect the supply of electricity to the working area and failure to take adequate precautions to prevent electrical shock resulted in the respondent's negligence to his own injuries. Further to the above, the respondent committed contributory negligence when he refused to see a doctor upon falling on concrete in front of his own home the very next day. As per findings in McHugh in Jocelyn versus Berryman, 2003, a plaintiff is guilty of contributory negligence when a plaintiff exposes himself or herself to a risk of injury which might reasonably be foreseen and avoided and suffers an injury within the class risks to which the plaintiff was exposed.
Can I just stop you there?
Yes.
How do you say he's negligent by not going to seek medical treatment? Hasn't he already received his injury? Isn't he already injured at this stage?
Yes, but under the respondent under the Wrongs Act 1958 Section 28 LG, he was required to see a doctor after the subsequent fall. So the medical practitioner.
Did he not go to the doctor?
Sorry?
Had he not been to the doctors or the hospital the night before?
He had been to the hospital previously the night before. He was dismissed and he returned back to work, and in fact he continued on working until 10:30 that night. It was the next morning he got up to leave for work, and upon leaving his front door he actually fell on the concrete, and he refused to see a doctor at that point. I'm quite sure he was urged by several people to look at the statement of facts.
Did he need to?
Yes, he did need to. Absolutely, because given that there was less than a 24-hour period of the fall happening.
So you're saying his behaviour was unreasonable?
To not seek medical advice the next day, yes.
And causation has been broken?
Somewhat through failure to seek medical advice, yes.
Please.
Just curiously, on the issue of the Electrical Safety Act,
Yes.
are you aware of any authority that, besides the operation of the legislation, is there any case law on this?
There's a body, it used to be the Chief Electrical Inspector, but that changed, and now it's just the electrical safety regulations. So they go through the same process as what the Chief Inspector used to go through. And
if the legislation is to the benefit of the worker, is it strict liability or is it...
it's strict liability. You can, if you don't comply under the certificate, he can be charged in court for criminal negligence. That's how important it is, the compliance certificate.
Are you aware of the decision of the County Court of Judge Burke in Vanderworth and Tesla?
No, sorry, Your Honour, I'm not.
In that case there, albeit it's not higher court. Her Honour found that the legislation didn't help the plaintiff because it didn't confer a private right of action for breach. The legislation was there for the public at large to protect the public. Continue.
Yes, but this legislation's not there to protect the public. This legislation's there to protect all electrical workers, to make sure that there's a safe code of conduct and that electrical work is set to a reasonable standard given the high-risk nature of working with electricity.
Her Honour does continue that this legislation does, it's more for the protection of the community by ensuring that electrical installation complies with industry standards, the rectification and reporting of unsafe work, regulation and disciplinary regimes.
In fact, the decision would support your argument.
Thank you, Your Honour. So, may I continue with my submission?
Yes, please.
Thank you. By refusing to seek medical assistance, the respondent was exposing himself to further risk of injury. On this basis, the appellant seek to have the claim of negligence defeated as per Section 63 of the Wrongs Act in 1958. I would also like to submit that if you were to find under 13AB of S13AB, the Accident Compensation Act, that the respondent unreasonably refused to submit to a medical exam the day after the incident, and as such a period of time the respondent refused to seek medical advice and should be disregarded in calculating the period of compensation as referred to subsection 7. In conclusion, we'd like to say that the appellant seeks to have the decision made by Justice Carlos in the original hearing of the matter to be struck down. On the appellants submit that Joseph is not a worker of commercial sparks engineering as a definition in Section 5 of the Accident Compensation Act 1985. On this basis, the respondent must establish that commercial sparks engineering breached the duty of care through the Wrongs Act 1958. The appellant submits that there was a duty of care on behalf of commercial sparks engineering and that this duty was not breached. Also, it is submitted that the respondents that solely commercial sparks engineering caused the harm that suffered. The appellants submit that this is not the case under Section 51 subsection of the Wrongs Act. And lastly, the appellant submits that if the matter of negligence is not found in our favour, the respondent contributed to the negligence that occurred as per Section 62 of the Wrongs Act 1958, and that the respondent's claim should be defeated as per Section 63 of the same Act.
What do you assess contribution at? What do you assess contribution at on behalf of the respondent?
Counsel, you're saying that if there is negligence,
yes,
then contribution's 100%. That's what you're saying.
Contributory negligence.
That's what I'm asking.
yes,
Yes.
that's
What
correct.
percent?
Yes.
Is it 50%, 80%?
No, 100%. The failure to turn off the electricity supply was crucial in this. He should have turned off the electricity supply. I think if I recall, at the start it said it was a warm day, a hot day, so that would lead to perspiration, which would lead to an earthen condition.
And he had control over that, as in
No, he didn't
failure?
have control over the weather, but what he did have control over was his actions in regards to the weather. Because it was warm, we all know that we perspire when it's warmer, and that creates an earthened...
But if he was provided with the appropriate gloves...
Well, actually, according to... I'll go back to that. According to... this incident occurred in 2010, and the regulations of gloves contained in the reg book was not actually required at that point in time. So it was well known among the electricians that perhaps you should have used the other sort of gloves, but the regulation didn't actually come in until 2012 in the new reg book. 2010, when this case had happened, it wasn't required in the reg book. So,
But if your client hadn't provided the gloves, then
yes.
the plaintiff would have had the respondent would have had to provide his own gloves.
Well, no,
In
it's
those
a shoot. We don't
circumstances-
actually. Sorry.
In those circumstances, it would have been very hard to find liability against your client because he would have provided his own equipment. And gloves are a pretty important part of an electrician's job, I'd imagine, in these circumstances.
Your Honour, I submit that the gloves as they were contained in the regulation books, the gloves would have then become part of the PPE, the personal protective equipment. So as of 2010, the gloves would have then been naturally included in the protection kit if they weren't already. But we don't know. We're just told that he chose one set of gloves. We're not saying we're not told if there were any more provided or he had a choice.
But it's a reasonable expectation that if a commercial contractor in electricity provides equipment, that you can assume that it's the right equipment, sure.
Absolutely, and we don't know that he hasn't.
Thank you, Councillor.
Okay, thank you, Your Honour.
Thank you. No.
Your Honours, I will be making submissions in relation to the first two grounds of appeal.
What was your name?
My name is Mr. Syed, and I'll be making submissions in relation to the first two grounds of appeal. That is that the respondent is a worker for the purposes of the Accident Compensation Act, 1985 Victoria. Your Honours, may I dispense with formal citations?
Yes.
And secondly, that the appellant or the applicant had a duty of care for the respondent. My learned colleague will be making submissions with respect to the third and fourth grounds, that is that the appellant caused the injuries to the respondent and that the respondent's injuries were a result of the appellant's negligence. Now, Your Honour, before I move on to the first ground of appeal, counsel for the appellant did state that the appellant owed a duty of care to the respondent. Would this court still require me to make submissions with respect to the second ground of appeal?
I'm not sure. Counsel for the appellant was saying if we found that Mr. Joseph was a worker, they owed a duty of care. So the issue of whether Mr. Joseph's a worker is alive and well. So
okay, thank you for clarifying that, Your Honour. Now, moving on though to the first ground of appeal. Now, just to clarify with respect to our submissions, as per 1.1, 1.2 and 1.3, this court need only accept one of these submissions to be satisfied of itself that the respondent is a worker pursuant to the Accident Compensation Act. Now, moving on to 1.1. Your Honour, we submit that pursuant to Section 5.1 of the Accident Compensation Act, the respondent was an employee because of the contraction, the nature of the contract between the appellant and the respondent. That is that one of a contract of service as opposed to a contract for services. It was an employer-employee relationship. Now, the test, which was expounded in the case of the High Court decision, which is binding on this court, Your Honours, of Hollis and Varbu, is that to determine whether a person is an employee or an independent contractor, the court must have regard to the relevant indicia which, when considered as a whole, so it's not just the formal contractual document, it's the entire relationship and nature of and how the parties regarded each other and their mutual intentions with respect to their conduct as well as the actual document, which when considered as a whole and weighing each of these indicia demonstrates or essentially reveals the true nature of the contractual engagement. Now, Your Honour, as per 1.1.4 of our submissions, we submit that there's 6 factors which on the facts reveal that on balance, it is evident that what we have here is a employment contract, and as a consequence of that, the respondent meets the definition of worker.
Can I just stop you there? You think you've got a stronger argument under Section 5 as opposed to Section 8? Is that what you're saying?
We submit that the argument under Section 8 is there as well. However, we feel that having regard to the facts of the case, we can mount an argument on behalf of the respondent, which essentially demonstrates that they can actually satisfy this definition. So the definition of a worker in the primary sense, as the case law.
Take us through those points that you say show he's a worker.
Excuse me, Your Honour?
Take us through those points.
Yes, absolutely. So firstly, the respondent had no control over the manner in which he performed his work. He sought instructions from the project manager. The project manager dictated what job he was required to do, where he was required to go, allocated the workers that he was required to work with. He had to act in accordance with the procedures that they implemented. He had no control or discretion in the manner in which he conducted his work. Secondly...
Can I stop you there?
Yes.
He had a high degree of control over how he did the job. He's a specialist electrician.
Yes, Your Honour.
And the appellant didn't have any control over how he performed the task. They brought him in because he's a specialist contractor. And so, how can you say that the appellant had control over how he did the work? They probably had control over where they placed him. They told him that this is a problem, we want you to fix it. But he's also a specialist at what he does.
Yes, Your Honour. If I refer you
and
to...
if you have and I'll bring you back to the Sharif case that I mentioned to counsel for the appellants. But in that case, Justice Beach found that a high degree of control over which plaintiff had in that case, and the defendant didn't have control over how he performed his task, is pretty significant. But what shot him down was the fact that he had his own employees, and I don't think, in your favour in this case, your client didn't have his own employees on the job. They were provided by Commercial Sparks, is that correct?
Yes, Your Honour.
But he did have a lot of control over how he did the work.
We submit that all the directions as to how the work was to be performed was in accordance with the Job Safety Assessment Act. That was essentially a process or a system of work implemented by the respondent. We do acknowledge that as a supervisor, he would work in a capacity whereby he was responsible for the other workers. We do concede on that point, but what we submit is that still there is significant control there on the part of the appellant as to how the work is to be carried out. As this was indicated in the first instance decision, Justice Carlos did mention that he wasn't able to perform a job safety assessment at his own discretion. He still had to comply with the procedures that were implemented by the respondent. Does that answer your question, Your Honour?
He's still a specialist, so he's got to do a risk assessment.
Yes.
They haven't said there is a fault in the field, isn't there, based on these facts?
Yes, Your Honour.
So alarm bells would be ringing. Being a specialist, unlike anyone else, you'd have to apply a bit of caution and discretion, I would imagine.
Your Honour, Ms Ficarra will be addressing as to the reasons regarding the, issues raised with respect to contributory negligence. But on that point, we do submit that he did take reasonable steps in seeking further instructions from the employer, as to how he should proceed in such circumstances. Moving on to the second factor, under the contract, and this, Your Honours, you did mention that the case of, I believe it was Sharif, the respondent could not delegate his task not that case, Your Honour. We submit that the respondent, though, could not delegate his task as a supervisor. Now, I would refer the court to the decision of Brodrib and Stevens. That was a case in which the High Court was required to consider whether or not the person who'd been injured was injured by an employee or an independent contractor of the respondent in that case. Now, it was found that the respondent in that case, essentially what would happen was the respondent Brodrib was essentially had been given grants by the government to essentially fell large sections of timber in the Ormond region. It had sought to engage others to help it carry out that task, and the appellant in that case was a truck driver, and the person of whom caused the negligence was in fact a snigger, so the one that would be chopping down the trees. And the respondent was responsible for overseeing the actual operation of that aspect of the timber extraction process, essentially. What had happened essentially in that case, we submit that it was found that both the appellant and the essentially the snigger was not an employee of the sawmilling company, because the snigger could delegate his task to other people, and he had frequently done so to his son. In this instance, it specifically states in the contract of engagement that the respondent must personally satisfy or carry out those duties.
Does that not flow from him having a special skill, though? How could he delegate his special skill to another?
Essentially, Your Honour, we submit that it would be reasonable to assume that the appellant could have others to perform that work. Essentially,
In the case you quoted, he was a truck driver, wasn't he?
yes, the person who was injured.
There's no special skills attached to that, apart from having a licence to drive a heavy work-life machine. Is that correct?
Yes. Moving on.
Yeah, whereas is Justice Richardson saying to you that in this particular instance here, your client, the respondent, is a specialist electrician.
Yes, Your Honour, that is just one factor. Having regard to the overall test, that is just one factor that this court needs to take into consideration. We submit that at 1.1.4 as well, the respondent was presented to the public as an emanation of the appellant. He wore the clothes of the respondent, and that was akin in the case of Hollis and Varbu, where the couriers in that case were found to be employees of the courier company, notwithstanding the actual formal contract appeared that they were independent contractors, simply because they were presented to the public as being employees. And in this case, this is exactly what's happened as well. So we request the court to follow the decision in Hollis and Varbu, which is also binding.
And the respondent didn't work for any other people, is that correct?
That's exactly right, Your Honour. And he was also paid by the hour, which also shows he wasn't essentially an entrepreneur. He was an essential aspect of the appellant's business.
Would that not indicate that he was a contractor, paid by the hour work? If he did the job, he gets paid. If he doesn't do the job, he doesn't get paid.
As in the case of Broderick, one of the factors that they found that the relevant persons were independent contractors was because they were paid on the basis of the amount of work that they completed. In this instance, he's just paid by the hour. It's not about the amount of work that he completes, how many jobs he performs for the appellant.
So you're saying he's getting paid a wage, a weekly wage of 40 hours or so? Is that right?
Yes, Your Honour. Now, moving on to my... I'll quickly, as I'm running out of time, Your Honours, I would have to ask if you could please rely on 1 point, just on my written submission as per 1.2. Moving on to 1.3, because that deals with Section 8 of the Accident Compensation Act. I will quickly My written submission clearly outlines how those elements are satisfied. Now, the appellant did allude to the fact that at section 8(1)(c)(3), they essentially stated that this provision doesn't apply to body corporate. Now, to my knowledge, Your Honours, there's actually, that body corporate is not specifically defined in the Act. Having regard to the textbook Commercial Applications of Company Law, 15th edition 2004, published in 2004, it states that a corporation or body corporate is the general term used to describe an artificial person created by law to hold property and legal rights and incur obligations. So separate legal personality, that's a fundamental characteristic of a company. Thus, we submit that Section 8 does apply to companies, and if you are to take a strict formalistic approach in considering this relationship and to say that the respondent is an employee of his company, Oversight Electrics, it's clear that 100% of as he can't delegate his task as supervisor, 100% of the obligations arising out of the contract with the respondent with Oversight Electrics is performed by the same employee, that is the respondent.
Counsel, in the short time left, can you go to the reasons for the applicant having a duty of care to the respondent?
Are you dealing with that issue? Or?
Yes, I'll be dealing with that issue. I will just move Your Honours onto 2.1.4. Now, I do apologise, Your Honours, with respect to this submission. Essentially, what our submission is that the if you make a finding that the respondent is a worker under the Accident Compensation Act.
Let's go to the duty of care.
Yes. Now, even if you find that he's an independent contractor, naturally, and pursuant to common law principles, naturally, an independent contractor and a principal, there's generally no duty of care there. However, in the case of Brodribb again, it's specifically stated that in that instance where the relationship was characterised as that of independent contractor and principal, on common law principles, a duty of care arose. So essentially...
I think that case works heavily against you in these facts.
Just one moment.
If your client is an independent contractor, I think you'd be struggling to establish a duty of care. It's in very rare circumstances where the court would say that there's a duty of care.
Could I direct the court's attention to page 514 of the judgment, whereby... No, sorry, Justice Mason at 522. It says, it is plain that Brodribb, that was the owner of the sawmill, could reasonably foresee that there was a real risk that the worker carrying out this was a truck driver, Stevenson's duties would sustain an injury of the kind that occurred. And he was injured by a dislodgement of a
So you're saying commercial should have foreseen in similar vein?
Absolutely. This is a high-risk essential contract. It's dealing with electrical installation work. It is very, very dangerous, and it's clearly foreseeable that if reasonable care isn't taken in implementing a safe system of work, that injuries such as this would occur. Your Honour, as I'm running out of time, I will have to conclude and request the court just to rely on my written submissions. Thank you for your time.
Thank you, Counsel.
Your Honours, my name is Miss Ficara and I am Junior Counsel for the Respondent. I will be making submissions in regards to the third and fourth ground of appeal, namely that the applicant caused the injuries to the Respondent and that the Respondent's injuries were a result of the applicant's negligence. In regards to the third ground, Your Honours, I will be making my submissions in three parts. Firstly, that the applicant's breach of its duty of care caused the injuries to the Respondent. Secondly, it is submitted that the applicant failed to take reasonable steps to provide safe equipment. And thirdly, that but for the applicant's negligence, the Respondent's injuries would not have occurred.
Can I just ask you one question?
Yes.
If we find that the respondent's not a worker, then worker, your case would be pretty difficult on the issue of breach. Or leave aside breach, it'd be very hard pressed to prove that there's a duty of care based on the decisions, Broadrip, that co-counsel enunciated, and also the case that followed Broadrip, McArdle and ANMAC roofing,
That's true, Your Honour.
and Congress's State Transport Authority.
Yes, that's correct, Your Honour. Hopefully, though, we can convince Your Honours that through the arguments that were posed that he is a worker, and hopefully my arguments can support that and show that the applicant was liable. I will now move on to my first submission. Your Honours, when deciding whether the applicant has breached its duty of care, the court must take into account the applicant's power to command, warn, prescribe and enforce. I do recognise, Your Honour, that you stated that the respondent is an expert and he is skilled. However, it has been shown in general cleaning and Christmas that it doesn't matter how skilled an employee is, there is always a risk, and he always has to be reminded of the risks that are surrounded with the job that he's doing. Because even the most skilled, the most advanced person can suffer an injury on a job site.
So what do you say caused the accident then? How was Commercial Sparks liable for the injury that took place?
Okay.
What could have they done that could have reduced the risks of the injury taking place?
Okay, so I believe, Your Honour, that opposing counsel actually conceded that the gloves that were provided were not adequate. From my limited understanding of construction sites, I believe that PPE equipment, PPE gloves are actually the lowest form of safety that you can give, and before you go to that, you should be trying, the contractor and the person responsible should be trying to first eliminate the risk, and if they can't do that, substitute it, either prevent it, reduce it or mitigate it. And if those factors can't be possible, then PPE equipment or PPE gloves or any sort of jackets or whatever can aid in protecting the employee is then issued. We can see here that obviously...
Can I stop you? Counsel for the Apellant said that the cause of the injury to Mr Joseph was failing to turn off the power, and that was the main cause, and the glove issue was just incidental. What do you say?
Your Honour, we submit that it's actually the employer's responsibility to make sure that the site is inspected. And as we're told on the facts, the employee was purely a supervisor, so he didn't have the authority to inspect the site. If we look at...
Did the applicant have that authority? This is a third-party site, isn't it?
It is a third-party site, Your Honour.
Didn't the third party engage the applicant, who thereafter engaged the respondent to work at this site?
Could you repeat that, sorry?
Didn't the applicant was engaged by the third party, who thereafter engaged the respondent to work at this site?
So in that instance, how does Commercial Sparks have control over the work site?
That's correct. And if we look at the case of Wilson and Tyneside, we will see that it was said there, sorry, Your Honour. Wilson and Tyneside, Lord Pearce pointed out, if the men are taught properly, provided with proper equipment, are adequately warned of the dangers, and are instructed not to perform work which appears to be too dangerous, but should instead report the matter to a supervisor, then it would be ridiculous for an employer to check every job site. It would be absolutely ludicrous. But in this case, he hasn't been warned. He hasn't been given the adequate
But he's got a
equipment.
special skill. We've
He's a
discussed-
specialist and he's running his own show. Why does he need the applicant to hold his hand in this regard?
Just curiously, what was the occupation of the plaintiff in Wilson's case?
He was a window cleaner, Your Honour.
Sorry?
A window cleaner. Yeah, and what happened there, he held on to the handle of a window and it wasn't attached properly, and because of that he fell. And he said that his employer should have checked the side and made sure that everything was intact, and he was also a specialist in his field. But the judge pointed out that if he had been warned, because, I mean, we are all humans, everyone makes a mistake, and therefore if your employer sends you to a job site and you call him and you say, you know, the earth light is illuminating, which from my understanding means that the cable has not been earthed and therefore there is a fault. He should be warning the employee or even telling him to evacuate. Don't start work until the site is inspected, because it's extremely dangerous. I mean, we're dealing with a lot of electricity here. It's not a minor
Isn't it
job.
within the realms of the respondent to know, as a specialist electrical contractor, what the dangers of those tasks entail?
That's correct, Your Honour. However,
And
if...
even the occupier wouldn't know what those dangers are, surely.
Yes, but if we look at Section 37 of the Electricity Safety Act, it states that a registered electrical contractor, who in this instance would be Commercial Sparks, must not permit a person to carry out, on the contractor's behalf, or direct a person to carry out any electrical installation work that does not comply with the Act. Therefore, they have that duty to tell him either not to work or make sure that they warn him and say, look, just reminding you that it's going to be dangerous. I mean...
But wasn't that piece of legislation introduced to protect the public at large, as His Honour Judge Karantzis said the counsel for the appellant? And not really there to protect specialist electricians like your client, like the respondent in this case?
My understanding of the Act, Your Honour, is it's in relation to workers and not the general public. If we look at Section 41A of a responsible person, it can be seen that the Commercial Sparks is the responsible person, and that they are the ones that have to protect their employees.
Just going back to the causal link, you said that, the applicants have said that it was because the power wasn't switched off. Explain to me how you say the employer in this situation should, could or would have reduced the chance of injury when it was his own knowledge and special skill that should have determined that the power was on and he should have turned it off.
Your Honour, we submit that... sorry, I've just completely blanked on what you just asked me. Could you please repeat that?
Well, the bench is concerned that the respondent is a skilled specialist and he's in control of the work being performed. How is the applicant liable for what's occurred to him when he's in control of the situation and of the work? That's what the bench wants to be satisfied of.
Because realistically, if the respondent's not being worker, as the law stands, the respondent's got a lot of problems. And are you aware of Apellant in the Australian Telecommunications Commission?
No, I'm not, Your Honour.
Can I just quickly read
Yes,
a
of course.
passage? When an independent contractor carrying on a particular trade is engaged by an occupier to work on his premises, the occupier is not under a duty to give warning of a defect in the premises if tradesmen of that class are accustomed to meeting and safeguarding themselves against defects of that kind. It's right on point. And that was followed that was 1984, by court, and it was followed by Davis and Norris in New South Wales in 2005. So what I said before was that if the respondent is not a deemed worker, you do have problems.
Counsel, you've got 2 minutes left. Please summarise your position.
Yes, Your Honour, I think I'll just conclude. So in conclusion, Your Honours, we submit that the respondent is a worker under the Act, and furthermore, a duty of care is owed and it has been breached in this instance. Commercial Sparks has acted negligently in regards to a safe system of work and is liable for the respondent's injuries. If you don't have any further questions, Your Honour,
Thank you.
sit down.
Okay.
Does counsel for the appellant want to provide rebuttal? Or
Yes, Your Honour, we would like to, with your permission.
you've heard what we've had to say about the issue of employer and employee. The case law is pretty clear that an employer's got a non-delegable duty of care to protect its employees. So our concern, obviously, if Mr. Joseph is an employee, his case is stronger. If he's not an employee, we believe his case fails. So probably the most significant point we'd like to deal with is the issue of employer-employer, I think.
Wonderful, Your Honour. That's what I'm here to address at the moment. Yourselves did start to go through some of the points in Hollis and Vabu Pty Ltd 2001 with the 6 factors that indicated a contract of service. Your Honours, yourself, you did mention the control over the job site. We believe that Mr. Joseph did have control over the job site. Essentially, he was the supervisor and he was in charge of the people there. You also went to the way in which he was paid. It was argued that he was paid by an hourly rate rather than on the basis of the amount of work completed. Essentially, we believe these are roughly the same things. If you're paid by the hour, are you not being paid for the work that you're currently doing? It would be a completely different matter if he was getting paid a wage, as you mentioned, but he is getting paid per the hour that he is on the job site. That is essentially him being paid for the amount of work that he's completing. It was also mentioned that the respondent and his business did not perform any work for any other businesses, company or organisations. As far as we can tell from the facts of this matter, we know the respondent himself did not perform any work for any other business, company or organisation. The rest of the company, however, we aren't given any information on. There's nothing to say that the company he started with his brother doesn't do any other work.
But on these facts, you've got to assume that he's working exclusively for...
He himself is, but it doesn't specify that the company isn't doing work for other people.
Can you take us through the issue of contributory negligence if we find for the worker?
Yes. Is there a particular point of contributory
What
negligence?
would you say comes off for contribution?
And why?
And why?
I would say that, just give me a moment to confer, I'll be as quickly as possible given the time limitations I have.
If the contrib goes to the PTY, not to him personally, and then you to the case.
Thank you. The contributory negligence should be going to his brother's company opposed to him. Opposed to our client, sorry. He's essentially suing the wrong people. He's not a worker of Commercial Sparks. He's an employee of his brother's company. He's suing the wrong people. We didn't cause any of the damage, and he's not a worker of ours. He would be a worker of his brother's company.
No, that's not the question. The
Oh,
question
sorry, Your
is,
Honour.
if we find that he's an employee of the appellant, what do you think should come off for contributory negligence if we find negligence on the part of your client?
Under Section 62 of the Wrongs Act and Section 63, we believe that 100% should be removed. He failed to turn off the electricity. That was his own fault. The gloves we provided would have been sufficient had he done so. and it was his own error 100%. So we
If your
believe
but if the gloves you provided were adequate,
Mhm.
he may never have been electrocuted in the first place.
the gloves we provided were adequate, assuming the power was turned off. He failed to turn the power off, and that action made the gloves inadequate. Under Rogers and Whittaker, it would be reasonable care and skill to have turned the electricity off as electrician. In failing to do so, he caused the negligence himself. Thank you, Your Honours.
Thank you. Can you close the court, please? Marin, can you close the court? Sine die. Adjourn the court, sine die, please.
Okay. We find that there's negligence, breach. Majority find that there's contributory negligence and take off 50%. If I found for the worker, I would have taken off 80% on those facts. But everyone did a good job. The only thing I'd say is just be careful when you're putting together submissions for a court of appeal, or in any court for that matter, because they're very well put together. The only thing is you want to be a little bit more concise, to the point, state the law as concise and short as possible, and quote cases and legislation. But then when you're on your feet, you should elaborate on what those points are. And the thing that concerned me a little bit, and also my fellow judges, is that there were some very important decisions that were either overlooked and I'm not really sure how they were missed. Papanatakis and Norris really support your position, just as much as Sharif and Elzak support your position. But I'm not sure if you've turned your mind to those, so I'm not really sure how you research these days, but if you hit Google, I don't know, I left law school 30 years ago, so I'm not really sure how to research anymore, but I've got plenty of people to do that for us. But it's very important that if you're going to argue a point, or if you're going to look at a case, or if you're going to deal with particular facts, you should be aware of all the cases that are relevant to the particular case. And without being too damning, because I think everyone conducted themselves quite well, you've got a reasonably big upside provided you learn from this, and provided you understand that it's not going to go all your own way when you're in court. 3 days into the job when I started in '85, I had a judge turn the strips off me, and I took a deep breath and said, "Your Honour, I'd like to deal with those issues." But they do like it if you're composed. They don't like you fighting with them. That doesn't help. But deal with the questions that are posed to you. Don't go off on a tangent, because occasionally that happened today. And remember, make sure that the law comes back to the facts of the case. Because what I found with the submissions is that you generally spoke about what the general principles were, but you should bring them back to the case and to the facts of this case. But I thought it was a pretty good presentation by both parties, and good luck with your future. I think you've got a good career, the whole lot of you, the 5 of you.
If I could say also, Stephanie, you had probably the hardest job, first counsel for the appellant. We were very impressed with your handling of the questions from the bench. You need to develop the arguments a lot stronger, particularly on a legal basis. However, you did have the hardest job. So good stuff. Naomi, again, you handled yourself with the questions from the bench very well. Again, development of the argument and the legal basis for your argument needs work, but again, excellent stuff. And Megan, development of argument and questions from the bench. You handled yourself very well. Congratulations, the three of you. The respondent, Christian, again, development of argument and questions from the bench. You really handled yourself well, especially the latter. You did probably give yourself not enough time on the second aspect of your presentation. And finally, Letitia, you had again, a pretty difficult job in summarising your position, and what I can say is development of argument and the legal basis of that needed further developing. But from me, congratulations to you all.
I'm just going to add on to what John and Tony have said. Well done to all of you. It was a bit harsh on, I think, all of you, but I enjoyed it. Yeah, there was a couple of standouts. John's already mentioned, but well done. It was really good.
Thank you.
What's that, sir?
I think it's hard to really make that decision because when the first person's probably at a massive disadvantage, I would have thought, and the others all of a sudden get a feel for what's to come. But most spoke clearly and we could understand. I guess just be a bit more concise and to the point. You're not going to get your way by just trying to ram the same point down someone's throat, because just say what you've got to say and keep moving. That's what I think. But they've all got a big upside. I think they're going to be good lawyers in the future, if that's the path they choose. And good luck.